So the challenges for employers are to manage cases which are becoming longer, they're public hearings, so you need to manage your reputation and morale back in the workplace and your external reputation as well. Over the years, successive governments have tried to change the employment tribunal system. Some of the changes have been very successful. So, for example, preparing written witness statements and exchanging them in advance of the hearing. It's hard to think back to a time when we turned up at the tribunal hearing not knowing what the other side were going to say exactly or how many witnesses they were going to have. So that's a very welcome change. Other changes have been more disastrous. We've seen the introduction of the statutory dispute resolution procedures and their subsequent repeal because they completely overcomplicated the system. But I think the changes coming up this year, in particular the change introducing fees to tribunals, are really quite significant. In this videocast we will be covering the four main changes. First, early conciliation. Secondly, fees in tribunals. Thirdly, changes to the tribunal rules. And fourthly, changes to compensation and penalties. And we will be dealing with these sequentially.
The current position in relation to conciliation is that ACAS is available to help the parties to settle a dispute. However, they typically only get involved once proceedings have already been issued and therefore once both parties have already spent some money on legal fees and positions have become more entrenched. The government is planning to introduce a new mandatory pre-claim conciliation process. Under this new process, claimants will be required to submit details of their claim to ACAS before being able to issue proceedings in the Employment Tribunal. The government wants to reduce the number of claims that proceed to the Employment Tribunal and therefore to reduce the running costs of the tribunal service. However, the government also wants to encourage parties to consider less acrimonious, more cost-effective and more flexible means of settlement, which is the intention of this new procedure. There are a number of stages to the new pre-claim conciliation process. The first stage is that the claimant will have to complete a form setting out their contact details and submit that form to ACAS. Once ACAS have received the form, then they will get in contact with both the claimant and the respondent to determine whether they'd like to try and settle. If both parties want to try and settle the dispute, then they'll have up to a month to do so, and if it looks as though they might need a bit more time, this can be extended by a maximum of 2-week period. If either party doesn't want to settle or if they can't settle in the time frame, then ACAS will issue a certificate which will enable the claimant to bring proceedings in the tribunal. The introduction of the new procedure will have an impact on employers. Firstly, employers are going to have to think about settlement at a very early stage in a dispute, and they might not be used to doing so. Under the new procedure, claimants only have to provide very brief details of their claim to ACAS, so employers will now have to consider settlement in an arena where they might not have much information about the claimant's actual claims or the prospects of success in those claims. So it might be quite difficult for employers to determine what a reasonable settlement offer might be. I think that the government is introducing this new procedure to try and bring about a cultural shift, so really to get employers and employees thinking more about settlement. However, I've got a number of concerns about the procedure. For one thing, the government is also introducing tribunal fees in July 2013. Now, tribunal fees will be payable by the claimants upon the issue of a claim and again on the hearing. So I question whether an employer will be prepared to try and conciliate before they can see whether a claimant will be prepared to pay the fees to actually bring proceedings. The government is still consulting on the proposals. However, they have indicated that they want to bring in the pre-claim conciliation process at some stage this year.
To date, employees have not been required to pay a fee in order to bring a claim in the Employment Tribunal. However, as part of the government's review of employment law, this is something that is going to change. And with effect from the summer of 2013, we will see the introduction of fees in the Employment Tribunal for the first time. The fees mean that in order to bring a claim in the Employment Tribunal, claimants will now be required to pay an issue fee followed by a subsequent hearing fee. The fees that will be payable by claimants will depend on the type of claim the individual wishes to bring. So what we will see is the introduction of a 2-tier fee structure being introduced in the summer of 2013. And this will introduce level 1 type claims and level 2 type claims. The fees for which will differ according to the level of claim being brought. Level 1 type claims will encompass the more straightforward types of tribunal claims that employees wish to bring, such as claims for unpaid wages and redundancy payments, whereas the Level 2 type claims will encompass all other types of employment tribunal claims, such as unfair dismissal claims, discrimination, whistleblowing and equal pay claims. The issue fee for a Level 1 type claim will be £160, followed by a subsequent hearing fee of £230. The fees will increase, however, for Level 2 type claims, where the issue fee will be £230, followed by a subsequent hearing fee of £950. As a result of the introduction of the new fee structures, it is hoped that we will see a decline in the number of vexatious claims being brought against employers. The hope being that the requirement for claimants to pay an issue fee will deter them from bringing vexatious claims in the tribunal. In relation to Type 2 type claims, we hope that the requirement for a claimant to pay a hearing fee before progressing to the hearing will result in claimants reconsidering their cases and assessing whether or not they may wish to conciliate with their employer through the services offered by ACAS. So ultimately, we feel that the introduction of the fees will impact on the way employers handle employment tribunal litigation moving forward, because effectively what we may see is employers waiting until after the claimant has paid the issue fee and the hearing fee before they take steps to conciliate. At the moment, the employment tribunal rules are 25 pages long and they are written in a very legalistic manner, which is considered to be slightly out of step with a forum in which employment tribunals welcome lay representatives and employees acting in person. As a result of this, the government is introducing changes which aim to simplify and streamline the current employment tribunals process, as well as providing consistency and clarity to all of the parties involved in that process. As a result of the employment law reforms, a number of key changes will come into force. The first being that judges will now have a greater power to assess and review claims at an early stage. What a judge will do is the judge will be able to look at the claim at the point at which it is submitted and consider whether or not there are any procedural irregularities which will allow him to strike it out. The judge also will be able to review the claim to consider whether or not the claim has reasonable prospects of success, and if it hasn't, he will be able to strike it out at that point. Tribunals will also now be able to set hearing timetables, which means that they will have the ability to impose time limits on the length of time an individual can spend giving evidence, cross-examining, or indeed giving submissions during the employment tribunal hearing. The impact of these changes, in particular the timetabling of the hearings, will now mean that employers more than ever will have to ensure that their case is prepared fully so that the case that is presented to the tribunal is as thorough as possible. Also, the initial consideration of the file by a judge should mean that the weak cases are now weeded out of the system, resulting in employers facing less unmeritorious and vexatious claims moving forward. This will be a very welcome change for employers, in particular those who incur significant costs in terms of the management time and expense that is involved in preparing cases for tribunal hearings.
At the moment, if unsuccessful at tribunal, an employer might be required to pay compensation. For unfair dismissal, the compensatory award is currently capped at £74,200, which many believe to be an arbitrary and excessive amount, given that the average award for unfair dismissal is currently just under £9,000. The government is proposing to introduce a new cap for the unfair dismissal compensatory award. This new cap will be equal to 12 months of an employee's salary, subject to an overall cap set at the current level. On the whole, these changes are likely to be welcomed by employers in the hope that they will help manage employee expectations of the levels of compensation that they could receive and therefore help promote early resolution of disputes. But employers may also be concerned that the change will simply encourage claimants to introduce a discrimination element to what would otherwise have been a straightforward unfair dismissal claim, because discrimination compensation remains uncapped. The government is proposing to introduce financial penalties against employers who lose at tribunal. The penalties will be between £100 and £5,000 and they will be levied at the discretion of the employment tribunal in circumstances where the breach shows an aggravating feature. So, for example, where the employer's behaviour is either negligent or shows some evidence of malice. And the government is introducing these changes in order to deter bad practice, to promote compliance and therefore reduce the number of employment tribunal claims. Well, there's a concern that this additional potential cost of litigation will simply put pressure on employers to settle unmeritorious cases. The aim of all these changes is to promote early settlement and ultimately to reduce the number of claims going to tribunal, but we will have to wait and see whether or not these changes actually have any significant impact.
I think employers will need to change their approach. First of all, there's going to be much more focus on early conciliation of cases. That's a nut which the system has singularly failed to crack over the years. Somehow, until the case is about to happen, it's just an abstract concept, and people haven't really thought through the fact that they might have to sit down and give evidence and be cross-examined and possibly not even win the case. So cases tend to settle the night before the hearing, but the new focus will be on settling cases very early. So that's a big change. Secondly, if cases do run, so if there's going to be a hearing, they need to be better prepared than they've ever been prepared. There are going to be guillotines, so you can't leave it up to some clever barrister on the day to pull the case round with his fabulous examination in chief and cross-examination. The case that you prepare has to be spot on. I think initially there may be a slight reduction in employment tribunal cases because some people will be put off by the fact that they have to pay to access the system. But we need to remember that not everybody has to pay. It will be means tested. And the other factor is that once somebody's paid to access a service, maybe they will fight even harder, so cases will be longer and more complex. Another potential problem, I think, is that the tribunal system itself is going to have to cope with all these changes. And at a time of austerity, are they going to be able to recruit more people to help, or are we going to see a big backlog of cases? I think tribunal cases are unlikely to go away. Employment disputes are not going to end. There still will be cases. I think they will be longer and more complicated, and none of these changes are really designed to deal with that. I think the hope is that the changes will make life easier for employers. One of the hopes is that it will deter people who are vexatious, who have hopeless claims. I'm not sure whether that is the case because the amount of the fees and the remission system, where not everybody has to pay, is perhaps not high enough to deter people who are determined whether or not they have a good case. We hope that you found the information in this videocast helpful, but in a changing world it's important to keep up with the changes as they occur. And we will be keeping you informed through our blog, through our alerters and through our regular training programme of seminars and workshops.